All right, good evening or good day, ladies and gentlemen. Now we're going to discuss Chapter 6, Defense Attorneys. And I have a personal, this is what I do. So I have personal knowledge to talk about, a personal knowledge base to discuss this chapter. I'm an expert. So, defense attorneys, introduction. The American court system is an adversarial system, and the cornerstone of such a system is having advocates representing both sides. The founding fathers recognized that for this adversarial system to function, persons accused of crimes needed to be represented by an advocate equally as skilled and educated as the opposing government prosecutor. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The defense attorney's role in the criminal justice system. As with all attorneys, defense attorneys are officers of the court and must adhere to significant ethical standards while also doing all they can to promote the interest and to protect the rights of their clients. While prosecutors are in the pursuit of the just outcome and justice, the defense counsel is in pursuit of furthering the interests of their client. It's about that individual client and not about the individual, not about the interest of society as a whole. We could care less about everyone else. It's this client that's sitting beside us and that we're representing right now in court. That's who we care about. Now, we may make arguments about the Fourth Amendment and how it's supposed to apply to the world and what it means, because the Fourth Amendment, your Bill of Rights and your rights in the Constitution, those are all our rights, right? But when it comes, I may argue that, but I'm arguing that for this one person. I don't even care what happens in the case that comes after mine because it's not my client. It can be the same facts, and that person can get totally screwed. I don't care. They're not my client. So that's literally the way we think, because we have to. And honestly, if you're ever in a pinch, you probably want an attorney and things like that. While I said that before, defense attorneys have an ethical obligation to zealously defend a client, even if he or she knows he is guilty. So sometimes it's not about guilt or innocence. It's about making sure that they're treated fairly. So some people say, how you go to bed at night knowing that person did that? It's not about that. It's about making sure, even if this person is guilty of it, making sure they're not railroaded and everything is done correctly and their rights are not violated. And they're not mistreated by the system. It is necessary that actions and claims made by the government prosecutor be tested and challenged by a zealous advocate to ensure accuracy and trustworthiness of case outcomes. So when a person is convicted at trial, or even by entering a guilty plea, at least we know by virtue of having a defense attorney on both sides that they had to, in order for the prosecutor to win or get that outcome, it had to go through a defense attorney who challenged it at every level. So if I challenged it and held it to a high standard and make sure they jumped all the hurdles, and they got what they want, that means they probably had an airtight case and they did what they were supposed to do procedurally. So defense attorneys actually make the system more efficient by we are the check to prosecutors. We're not much of a check because it's nothing we can do about their discretion, but we are a check because we are the opposing side and we're the adversary, so we help keep them a little bit humble, as humble as you can ever keep a prosecutor. That's hard to do. Let's see. Okay, to effectively put the prosecutor's case to the test, a defense attorney must be able to, 1, challenge the reliability of evidence presented, 2, cross-examine witnesses against the defendant, 3, raise matters involving violations of the defendant's rights, regardless of whether the defendant is factually guilty. The historical development of the right to counsel. Of course, under the English common law system, we talked a little bit about it before, but from the prosecutorial perspective, remember English common law, of course, it was private prosecution. So if someone did you wrong, you had to come to court. There was no prosecutor, and you said, he did me wrong, he stole my horse, and you were the prosecutor. So that means on the other side, they didn't have an attorney either. But once the system changed, especially once we got to America and we became our own sovereign nation, and the population began to grow, we realized we wanted actual professionals to be prosecutors. That meant the same thing would have been demanded on the other side. If we're going to have professionals and lawyers prosecute cases, that means we need to have professionals and lawyers defending cases. So during the colonial period, this prohibition of counsel changed as colonies transitioned from private prosecution, as I said before, of cases to the appointment of prosecuting attorneys. It was only fair that defendants have professionals to defend them against the litigation of other professionals. After the Declaration of Independence, the Sixth Amendment, and of course the country becoming a sovereign nation and the Constitution being created, the Sixth Amendment was included in the Constitution and promised the right to counsel. We're going to talk about briefly about a few cases, just the holdings of the cases. Powell v. Alabama, or the Scottsboro Boys case. In that case, defendants, the court said defendants require a guiding hand of counsel at every step in the proceedings against them. Without it, defendants face the danger of conviction because they do not know how to establish this innocence. A lack of counsel denied the defendants in this case due process under the law. Then you have Johnston v. Zerbst, or however you say it, 1938 case, and that Scottsboro case was from 1932. So 6 years later, 1938, in the Johnson v. Zerbst case, the Supreme Court expanded the reach of the prior case, the Powell case, in federal courts to include the right to counsel possessed by defendants who cannot afford to hire an attorney. It applied only to federal courts. Court-appointed counsel is private attorneys who are paid by the state on a case-by-case basis to represent indigent defendants. Then the next case you have is Betts v. Brady. This is from 1942. So 4 years after the Zerbst case. The Supreme Court held that the 14th Amendment's due process clause did not mandate counsel for an indigent defendant charged with a felony offense in the state court. So that killed the whole indigent people, indigent defendants deserving or having the right to counsel. So of course, years later, Gideon v. Wainwright came and it overturned that Betts case. It overturned Betts and held that indigent defendants, so Gideon v. Wainwright is very important. It came out in 1963, but it held that indigent defendants charged with a felony in state courts must have counsel provided to them at the state expense. The right to counsel is essential to a fair trial and is therefore incorporated into the 14th Amendment's due process clause and was binding on the states. Did not address the Gideon v. Wainwright case did not address whether there is right to counsel in all criminal prosecutions, including petty offenses and misdemeanors. It didn't address at what point in the court process the right to counsel attaches. It also didn't address whether the right to counsel applies to post-conviction proceedings such as appeals or habeas corpus filings or probation and parole violation hearings. So it was kind of general. It didn't say exactly what. So that's why we had cases after that kind of gave us clarity. Limits on the right to counsel. The Argersinger v. Hamlin case from 1972, it expanded the right to counsel to misdemeanors that expose defendants to jail time. The right to counsel plays a vital role in providing defendants with a fair trial regardless of the seriousness of the charges. This also prevents assembly line convictions. So just because it's small and misdemeanor court, you don't have a right to counsel, or as an indigent defendant, you're pretty much just coming there to be guilty. And it's a conveyor belt and everyone's guilty with no attorney, or not being able to afford an attorney, which would essentially be fair. Be unfair. So that's like assembly line prosecution, and that's terrible. Later on, 7 years later, 1979, another case, Scott v. Illinois. A defendant may not be sentenced to jail unless that person was represented by an attorney or voluntarily waived the right to counsel. There was an obvious concern that the system would be overwhelmed with the new requirement for appointment of counsel in thousands of new cases. But that was a long time ago, and it hadn't been a problem. We found a way to pay for it. And because it was crazy when even though court-appointed counsel and public defender and having a public defender represent you does not mean it's free. It just means there's no upfront cost. So if your case is dismissed or you're acquitted, then you don't have to pay for it. If you plead guilty, then a part of your guilty plea and your court costs and your fine and your restitution is going to include the hourly cost of that attorney. So you do pay for it, just not right up front. At what point is there a right to an attorney? The right to counsel attaches at the initiation of formal adversarial proceedings, when the accused is arrested and brought before a judge for an initial appearance, when the accused is indicted or formally charged with the crime by a criminal complaint. Once the right to counsel has attached, a defendant has the right to an attorney at all critical stages of the court process. What are critical stages, you asked? Any stage of a criminal proceeding where substantial rights of an accused may be affected. So pretty much it's all, they can be screwed on their rights at any stage. So once the adversarial part starts, you're charged, you're arrested, that starts the clock. You now have a right to an attorney. The core purpose behind the right to counsel was to provide assistance when the accused was confronted with both the intricacies of the law and the advocacy of the prosecutor. A defendant has a right to have a lawyer appear on his behalf at essentially all court proceedings following the commencement of a criminal prosecution. Once the right attaches, prosecutors, police, and investigators may not contact the defendant, let alone interrogate him in the absence of counsel. They have to do everything by permission of the attorney. So even if they want to talk to my client, they have to ask my permission. And of course I'm going to be there to advise my client while they're talking to him. Now, indigent defense systems. These are essentially systems that provide for the defense of people that can't afford an attorney. And that's what indigent means. Indigent means poor or unable to afford an attorney. Given the fact that 90% of criminal defendants are indigent, which is a large number, the magnitude of the responsibility placed on states to provide attorneys for indigent defendants cannot be overstated. State and local governments work hard to provide counsel to indigent defendants as efficiently and inexpensively as possible. Assigned counsel programs. Assigned counsel programs employ private attorneys to represent indigent defendants. Ad hoc assigned counsel. This is a system under which the appointment of counsel is generally made by the court on a case-by-case basis when necessary. Attorneys are usually paid on an hourly basis. In some states, attorneys are provided with a flat fee per case. In some jurisdictions, private court-appointed attorneys must petition the court for funds for investigative services, expert witnesses, and other necessary costs of litigation. Ad hoc assigned counsel method is the predominant indigent defense system used in the country. It's usually in smaller jurisdictions. Like some places don't even have a public defender's office. Like Guilford County, we have one because we're a big court system. But just next door in Alamance County, they do not. Everything's on a court-appointed basis, on an ad hoc basis. It's a little bit different than ad hoc because they do it pretty much based upon a list, and it's kind of cyclical. So it's a cycle, and then they roll through a list, and whoever's next gets this type of case. So they have a list. But it's essentially the same thing, where they have private attorneys doing all the court-appointed work. There's no public defender's office. Like I said before, it works well in smaller rural counties that have limited demand for indigent defense services. The drawbacks of ad hoc appointment systems are the lack of control over the experience level and qualifications of the appointed attorneys, as well as the potential for judges funneling work to preferred lawyers. So that's why they do it now by listing who's next as opposed to who the judge wants to appoint. Because I could have friends of the judges that give me all the cases, right? And I could be making bank. But that wouldn't be right. It wouldn't be fair. Now, another type of system or program besides the ad hoc assigned counsel, you have coordinated assigned counsel system. It's a system where attorneys apply to be included on a list of counsel to be appointed on an as-needed rotational basis. And that's like what they do in Alamance County and most small rural counties in North Carolina. Attorneys are paid on an hourly per case basis. The primary benefit is that it allows the court or a governing body to require attorneys to meet minimal qualification standards to be accepted into the program, so they can control the quality and of the attorneys there and know what their expertise is. So there's a little bit more quality control. Because the appointing authority knows the background and level of experience of each attorney eligible for appointment, experienced attorneys can be appointed to highly complex or serious cases, while less serious cases can be handled by less experienced lawyers, so they can delegate accordingly. Then the next you have contract attorney programs. A state or county attorney enters into a contract with one or more private attorneys, law firms, or nonprofit organizations to provide representation to indigent defendants. Such contracts are normally designed for a specific purpose within a court system, such as felonies, misdemeanors, or all cases where the public defender has a conflict of interest. Indigent defense services will periodically advertise requests for proposals under which attorneys, law firms, and nonprofit organizations can bid for a contract. Of course, you normally take the lowest bid. You have a couple types of contract programs. One, the fixed price contract program where the contracting lawyer or law firm agrees to accept an unknown number of cases within the contract period, normally 1 year, for a single flat fee. Contracting attorneys are usually responsible for the cost of overhead, support services, investigation, and expert witnesses. Even if the caseload in the jurisdiction is higher than was projected, the attorney is responsible for providing representation in each case for the original set price. The negative aspects of fixed price contract programs. The inherent incentive for the attorney to spend as little time and expense on the case. Because if I get one flat rate and I got to represent all these people, and I'm not saying as if I would do it, but you got to put yourself in that attorney's shoes. I want to spend, because I got this set amount of money and I essentially get to keep for my firm what I don't use. I'm going to probably cut corners. I'm essentially going to try to represent this person with as low overhead, with my overhead being as low as possible. So like I said, they're responsible for overhead support services. Like I said, there's an incentive for an attorney to spend as little time and expense on each case as possible. The lack of oversight of the competence of the attorney handling each case for a law firm that has entered into the contract. So you might have a contract for a firm, and that's just for the firm, but the government agency doesn't know what attorneys are working the cases within the firm. So they could pass the case to the least capable or least experienced attorney in the firm, because the contract isn't with one attorney, it's with the firm. So you don't know they still don't know who's working the cases. Law firms have been known to have their least experienced attorneys handle a majority of cases involving indigent defendants, to refrain from employing investigators or expert witnesses, and to take all steps possible to dispose of cases prior to trial. So if we can keep from having the expensive trial and plead out, even if it's not necessarily what's in the best interest or what our clients want, we can save overhead. We can keep some of that set price, that fixed price money we've already been paid out. The quality of representation suffered, which is why the use of fixed price contracts has been condemned by the American Bar Association. So fixed price contract programs are pretty much null and void, or what I will say is the American Bar Association does not like them. They have been publicly condemned. The next type of contract program is the fixed fee per case contract. Systems where the contract entered by the attorney or law firm and the local government entity agrees to a specific number of cases to be handled for a fixed fee per case. So that means you essentially pick the number of cases, this is how many I'm going to handle, and this is what you're going to pay me per case. And you agree on it and have a contract. The contracting attorney or firm submits a monthly statement indicating the number of cases handled during the period. Once the predetermined number of cases has been reached, the option exists to renegotiate, extend, or terminate the contract. It's a less common system than fixed price for jurisdictions that use contract system for indigent defense. So most systems are using that fixed price, even though the ABA doesn't necessarily like it. If they're doing contract at all. So a lot of jurisdictions aren't even doing contract stuff. Contract programs have been introduced as an alternative to court-appointed attorneys handling conflict of interest cases in jurisdictions that have public defenders' offices. Contract systems appeal to funding bodies because the ability to project cost for the upcoming year accurately by limiting the total amount of money that is contracted out. It is impossible to predict cost in assigned counsel systems. So if you have a contract system, you know what the cost is going to be. So from a budgeting standpoint, it's easier to plan if I'm the government entity. So now we're going to talk about public defender programs. Public defender program is a public or nonprofit institution designated to provide representation to indigent defendants in criminal cases where the office directly employs staff attorneys whose sole job is to provide representation to indigent defendants. The chief PD or public defender is normally appointed by a governing body or in some situations is elected by general ballot in some jurisdictions. Public defenders' offices employ full-time investigators, support staff. They have budgets to hire expert witnesses and even hire attorney staff as needed. PD offices are predominantly used in larger jurisdictions with a significant number of criminal prosecutions, like Guilford, Mecklenburg, your Wake County, your bigger counties and your bigger jurisdictions, Forsyth. They have public defenders' offices. Gaston County, they have public defenders' offices. Matter of fact, who else? Cumberland County, they have public defenders' offices. So it's usually for your larger jurisdictions. Other jurisdictions just do, if not contract, they do just court-appointed work where they do the rotational system where they have attorneys that are on the list. Okay, PD's offices. Okay, let me see. Cases usually assigned to individual assistant PDs based on the attorney's experience and the seriousness and complexity of the charges facing the defendant. I spent pretty much the first 4.5 years of my career, almost 4.5 out of the first 5 years of my career as a public defender. So as I was there, of course, started off with a caseload, and I inherited a caseload because I replaced someone that was leaving. So I literally replaced someone. That last day was on a Friday. I started the next Monday. We had a transition process. So I essentially inherited a file cabinet full of cases. I didn't have a slow day or a start where they slowly gave me cases. I think my first day in court, I was carrying a stack of files like this, day one in court. I couldn't even tuck them under here. I had to carry them like this. And that's my first day in court as a public defender. I was working. So I didn't get that transitional part. Now, the cases I represented were primarily misdemeanors and traffic offenses, but it was a lot of them. Of course, once I gained experience, I graduated up to doing felonies, mid-range felonies and doing other stuff in probation violation court. And I learned and I ended up earning a pretty large caseload. I think by the time I left, I had over 300 files in my file cabinet of some sort, closed and open open cases, stuff like that. So I had a lot going on. I was working my butt off, and I enjoyed every moment of it. But it just shows how they divvy the cases out based upon experience. PDs normally handle all aspects of a case. So once I got a client, of course, I wouldn't even get the client until after they've already been through a first appearance and asked for court-appointed counsel. Then I get them. So they've already had the preliminary hearings and stuff like that not arraignment, but the first appearance and stuff like that before I meet them. But after that, I'm the attorney all the way through the end. Where is that? Okay, yeah. Okay. An untrue but fair assumption is that PDs provide less effective representation than attorneys in the private sector. This is not true. I mean, matter of fact, I'll say that the public defenders probably have the most resources, and that's all we do is criminal law. As a matter of fact, because we were salary state employees. We didn't. So now, as a private attorney, you see my my logo behind me. I'm a businessman, so I don't only represent clients, but I also have to think about business, making money, the bottom line, paying this, paying that. As a public defender, I didn't have that word. I just went to court and represented my clients. It was pure defense attorney work. That's it. No business to it. No having to worry about making ends meet through my law firm and paying paying out bills and stuff like that. It was just me being a public defender for a salary, a decent salary for a 26 or 27-year-old guy who was fresh out of law, not too long out of law school, taking my first legal job. So I think I was paid well to be in that position. It wasn't a lot of money on the grand scheme of things, but at that point in time, I was living decently. All I had to worry about was representing my clients. I had a whole bunch of resources at my disposal, books, seminars, stuff I didn't have to pay for. They were making me a better attorney. So that's what you. As a matter of fact, your smartest attorneys in the courthouse are usually in the criminal justice system are your public defenders. As a matter of fact, a lot of times in court, the judge would be stuck and not know what to do legally in a certain situation, and the DA couldn't answer it, and they would call public defenders in. Hey, what's going on here? Because we were like the courthouse criminal law encyclopedias, and because we had to be. And one thing about public defender work, public defense, and just in general court appointed work, is we have to take the clients as we get them. We're not in a position to pick and choose who we want to represent. You get the case. And every case is an adventure. You open up that file, and it's something crazy. This person has multiple levels and issues, and you have to work within that, and it makes you sharper. That's one thing about being, and we talked about the prosecutorial side in the earlier chapter. One thing about being a DA, it does not saying that DAs don't use reason, but their job does not require that they use reason. In centralized DA's offices where they have a whole bunch of, procedures, and this is how it goes. That stuff is mindless. You do it just because. There's no rhyme or reason to it. You don't have to think about what you do. But as a criminal attorney in general, at all times, I have to be smarter than at least two people. If not be smarter, not about being smarter, but I have to outthink at least two people, a prosecutor and a judge who is normally kind of leaning prosecutorially. So I got to be sharp at all times. So it makes you a sharper attorney. And then being sharp and having to be sharp in situations where, for one, we never control the outcome. And then we also, in public defense, you don't pick your clients, right? So you take the clients you're given, and they have some pretty complex situations. So it's like a puzzle every time you get a new case, and it makes you sharper. So I feel like I'm the defense attorney I am now because of the public defender's office. I'm the businessman that I am now because of private practice and working for other private attorneys. But I'm the criminal defense attorney I am because of the public defender's office. So a lot there. Although overworked, PDs and their offices have the capacity to handle large numbers of cases efficiently because of the fact that the criminal defense in a single jurisdiction is the sole focus of their work. You got one, as a public defender, you got one courthouse to be in every day. Now I might have 3 or 4 to be in every day. So I got to worry about this and that, moving from client to client. Then I got to go to being a businessman and doing what I need to do to bring money in here. But as a public defender, had one place to be all day. That was the Green Courthouse right over in Greensboro, state courthouse. Handling my cases in my office. It was the law office of Britton J. Boyce within the public defender's office. So I was assigned my cases, and it was my job to organize them and represent them. And that's all I had to worry about. I didn't have to worry about rushing to some other courthouse or being all these places. I just worried about my cases, and that there was a freedom in that, and I was, so I could be sharp. I'm still overworked. I'm just overworked differently. So all defense attorneys are overworked if they're working, if they got clients. Um, this is what it is. So I think that's an untrue assessment of public defenders. Um, Another good thing about it, because you're in the same place all day, and you build rapport with other court personnel, so you have familiarity with procedures, and it makes you more efficient. You know how it runs. You know what's going to happen. You know the personnel. Sometimes it's what they call it, KYP. Know your personnel. Because you're in court all the time, you know these people. You know what judges to do stuff in front of. You know what DAs to deal with. So that's a good thing about it. That's one thing you learn and you master as a public defender. Also, appearing in front of the same judges with the same prosecutors on a daily basis, as I just said, it facilitates a work group cohesion. You build rapport with these people. You're able to negotiate with them, and even sometimes build friendships. Some of my best friends in the courthouse were prosecutors. And we hooped every week, went out on the weekends, hung out, and everything. But this may lead to and it leads to better outcomes, because this is the person I can talk to candidly about the situation, even off the record about, hey, this is what my client's got going on. Come on, understand me, help help him. And I could do that because I built rapport. Public defenders offices have investigators on staff and funds budgeted for expenses associated with expert witnesses. So in other situations with private attorneys, either we foot that bill or the client foots the bill. I don't foot the bill in my office. If anything needs to be done outside of normal court stuff, I tell my client that's on you. And if the private attorney, someone that hires me, I can't pay for that for what I'm charging you. You have to be prepared to foot that bill. So the good thing about public defender's offices is they have those resources as well. Then, like I said, more resources at the disposal of PDs and regular learning opportunities for attorneys on staff, as I said before. Private versus appointed counsel, which is better? PDs and appointed lawyers are often seen as being in cahoots with prosecutors. Totally not true. We just have a rapport. So I think a lot of times clients expect you, if you're not cussing out the opposing counsel, they think you're being too nice to them. It's like, no, I have to work with this person every day. You just sit there and hush. Let me be the lawyer. Attorneys who are hired tend to spend more time with their clients than appointed attorneys. This is due to a larger number of cases with public defenders. Also due to the expectation of customer service with private representation. So if someone hires me, they had to come into my office and meet with me anyway. So I had to meet with them. If I didn't meet them in person, I at least had to talk with them on the phone and have a conversation. I had to build a rapport to get them to hire me to do a service for them. And so I'm in the game trying to get hired. So I'm putting forth my best effort, my best customer service face, and I'm spending time with them. And that's one of the things we have to do as private attorneys. So yeah, we do, as a private attorney, you do spend a little bit more time with privately hired clients. Now I'm a private attorney, but I also do court appointed work. And I can tell you there's a difference between my clients who come in to hire me and my clients who I'm appointed to. A lot of times my clients who I'm appointed to, you'd be surprised, I've done more for their case and I care more about their case than they do, because I very seldom get calls from my clients before court. I have to go to court and call a name out like, oh, that's who you are. When I've been in their case, I was appointed last month. You didn't call me. They gave you my number in court. You didn't set an appointment to talk about the case, and I would have, set up a consultation to talk to you, but you'll be surprised. So a lot of times the clients have a lack of care as well in court-appointed cases. But in a case for hire, for persons coming to spend large sums of money in return for you doing a service for them, then they're going to come and talk to you. They want to feel you out and everything. So I'm spending time with them. I'm building more rapport, as opposed to someone who didn't choose me that got me because I'm on the list. So it is different. Attorneys who are, let me see, there's little to no, but the thing about it, even with that time and stuff like that, there's really little to no variation in case outcomes. The case outcomes are the same. From public defenders to private attorneys. And the reason being, I think a lot of times the system and people put more on the attorney than they do the facts and what happened. Because people don't want to blame themselves for why they're in court. So as an attorney, and I call that managing unrealistic expectations. So a lot of times you'll have a client that says, yeah, man, even though I'm on tape doing it, I don't want to go to jail. I'm going to do this. I don't want to do this. And I'm going to hire an attorney because they're going to get me this. It's like, just because you hired an attorney does not change the facts. Facts are what drives what happens in the case and how a case ends, not necessarily the attorney. Some attorneys can get a little bit of a push, a little bit better, but those outcomes aren't that much different because yo dog, we got you on tape committing the crime. So whether Johnny Cochran's your attorney or Brenton Boyce, the public defender, is your attorney, the evidence is what the evidence is, and we cannot change that. We do not create facts. We are not magicians. We it's dropped in our lap. We catch it, and we have to take what we got. So a lot of onus is put on that, and a lot of unfair treatment of public defenders and court-appointed attorneys is out there, and attorneys in general. Retained counsel and retained counsel is when you retain or hire someone. Effective assistance of counsel. What is the test? The test whether or not something the attorney does is ineffective or amounts to ineffective assistance of counsel. It's called a Strickland test. It comes from a case. The standard for judging a claim of ineffective assistance of counsel is whether the counsel's performance so undermined the proper functioning of the process that the trial cannot be relied on as having produced a just result. It's a two-pronged test. One question: was the attorney's performance deficient, or was there a problem with the performance? Two, if so, did that deficiency or problem in the performance injure or prejudice the defendant? So just because an attorney is bad and sucks and makes a bad decision doesn't necessarily mean it changed the outcome of the case. So there can be an attorney that's not that great, but once again, sometimes your facts are not that great. So whether an attorney sucks or not, you still on tape committing the crime. So it doesn't matter how good or how bad the attorney was. How good or how bad that attorney was didn't really materially affect the outcome because the evidence against you is what it was. That's another hurdle to jump. Right to self-representation. Ferretta v. California, 1975. The Sixth Amendment may not be used to prevent a competent defendant from self-representation. And we call self-representation pro se representation. So when you're going pro se, that means you're doing something very crazy and you're representing yourself. As they say, the lawyer who represents himself has a fool for a client. But if the defendant knowingly, intelligently, and voluntarily waives his or her right to counsel, that person will be entitled to proceed pro se. Now, pro se defendants are treated just as attorneys would be treated, and the judge would not provide legal assistance or advice or any special treatment just because you decide to represent yourself. In deciding to represent yourself, you're now held to the same standard as an attorney. So not knowing the objections, not knowing the rules of evidence, that is no excuse. You decide to try the case, so you got to try the case. Let me see. Typically, judges provide defendants who insist on proceeding pro se with standby counsel. Standby counsel does not formally represent the defendant, but acts as an advisor during the proceedings. This advice involves procedural matters and issues involving rules of evidence that are unfamiliar to non-attorneys. Next, we're talking about the right of an attorney of one's choosing. An indigent defendant has no right to choose whom he or she wants as their attorney. You take who's on the list, and that's what you get. You can't walk in and say, I want Boyce. No, it don't work that way. You take who's next on the list, and you got to keep it moving. So the Constitution guarantees that an indigent defendant be given effective counsel, not counsel of their choosing. State v. Gonzalez-Lopez, 2006. Denying a non-indigent defendant counsel of his choice violates Sixth Amendment right to counsel. Now, if you're paying for an attorney, on the other hand, you can hire the attorney of your choice, and the court can't keep you from hiring that attorney unless there's some type of conflict of interest or something. But otherwise, outside of that, you can hire the attorney as long as they're licensed in the jurisdiction and stuff like that. You can hire the attorney you want. The court can't keep you from going out and paying for the attorney you want. That's what Gonzalez-Lopez says. It said, denying a non-indigent defendant counsel of his choice violates the Sixth Amendment right to counsel, a fundamental right regardless of whether a fair trial took place or not. Depriving a person of the attorney of his choice when they're paying for the attorney affects the entire context in which the trial is held, making it a structural error rather than simply a procedural error. The right of the defendant to be defended by the counsel he believes to be the best that he can pay for is a right. Now we're going to talk about ethics and lawyer-client relationships. There is a duty to provide diligent and competent representation for clients. This responsibility includes counseling the defendant, investigating items relevant to the case, pursuing favorable disposition through plea bargain or prior to trial, zealously presenting the defendant's case in court, challenging the prosecution's evidence and cross-examining prosecution witnesses at trial, ensuring that the defendant's rights are honored and protected. The most important component of building a client's trust in his attorney is the assurance that what is said between the attorney and client will be kept confidential. Without confidentiality, the client would not be candid, which would negatively affect how the attorney represents him. So there is a rule that attorneys don't have to disclose client confidences. They can't make me testify or say anything a client has said to me. Now, there are situations where if I do choose to divulge that, it would have to be for a specific reason. Like this person has talked about future harm they're going to commit. I'm going to blow up a building tomorrow. And I'm like, okay. If it's that, I can break the rule, but they can't make me break the rule. But I'm covered if I break the rule. If that's why I violated the confidences. But in general, they can't make me divulge the confidences of my client. Okay. Other things that foster good working relationship between client and lawyer: meet with the defendant as soon as practical following the appointment or retention. Explain in detail the procedures that will take place as the case progresses. Promptly respond to the client's questions or requests for information. They need it. They want to be heard from. It's hard because only one me, but I got to try to respond to them. Keep the client informed of developments in the case on a regular basis. Distrust. Now, next, we're going to move to distrust of attorneys stems from, one, the environment and conditions under which a defendant is provided with an attorney. You got to think, if you need a defense attorney, something bad has already happened because you need a defense attorney, right? So just you having to hire me or having to be having to be appointed to me is negative in and of itself, right? So you're already coming in with some negativity. Because no one wants to have to need an attorney, a defense attorney for anything, right? It's rare that attorneys meet with their clients under positive conditions. Usually, it's not a positive condition. Even if it's a traffic ticket, you got a traffic ticket. That's not positive. The client is likely to be scared of what may lie ahead, confused by the process, and leery of the attorney sitting across the table. It is difficult to manage unrealistic expectations of a client. Some clients come in knowing they sell drugs, they do what they do. They've been listening to Jay-Z. I'm gonna beat the charges like Rocky. I'm gonna beat the case. It's like, bro, you on tape. You had cocaine in your pocket. So the expectations can be up here, but realistically, their case is not strong. And it just is what it is. What else we got here? The near autonomy, which is just the choice to choose, with which attorneys make strategic decisions on how to conduct a defendant's trial, is also a source of distrust because we have autonomy over everything but the constitutional stuff. When it comes to the tactical or strategical stuff, that's us as an attorney because we're the professional. And sometimes our clients want to be in on that. Now, it's a good practice for client control to tell the client and explain what stuff means and what you're doing tactically. It's when you're silent about it, the clients get worried. Like, yo, he ain't talking to me. You doing what? Hey, you tell me about that. So communication is always key in all this stuff. The defendant has the complete control over constitutional aspects, like those major decisions, like whether or not to plead guilty, whether or not to waive a jury trial, or whether or not to testify. On the other hand, attorneys have autonomy over, even whether to appeal, but attorneys have autonomy over the tactical stuff, tactical and strategic. Okay, you want to go to trial, now I have to plan and be strategic. So decisions like whether to call a specific witness to testify, how to cross-examine prosecution witnesses, whether an affirmative defense such as self-defense insanity should be raised, whether potential jurors should be challenged for cause or removed, or jury selection, whether to employ expert witnesses, or whether to give an opening statement or a closing argument. All that stuff is tactical. It's the kind of procedural, tactical stuff that's a part of the what I call it. It's the technical part of it. So also the advice and counseling the lawyer provides that are less positive than the client envisioned and may include an attorney refusing to partake in unethical behavior on behalf of the client. Like I said, managing expectations. Sometimes I have clients, because they come in with their facts. I didn't make the facts up. I wasn't there that night they got the DUI. I wasn't there the night they got caught with a key of cocaine in their trunk or in their back seat. I wasn't there. I'm just the attorney that's here to represent you. So they come in with these unrealistic expectations and very bad evidence, and sometimes I don't have good news. And sometimes that affects how my clients feel about me, because if as an attorney, the only good thing about your case that I had to say to you today was, "Hey, how you doing?" and that has nothing to do with your case. That can affect sometimes the trust level of an attorney. Like, we don't make facts. The facts are made and done when we get there. We're just responding and trying to plan tactically around the facts and to try to advise you to do what you do certain things. Now, the realities of being an attorney. This is the part. So people think of defense attorney as being glamorous and all this stuff. Here are the realities. One, although attorneys represent individual defendants, they operate within the confines of the courtroom work group. So we're controlled by the courtroom rules, the local rules, and everything that goes on in the courtroom. We have very little power. We're just defense attorneys. We don't determine when our cases get called. A lot of times my clients like, "Why I've been here all day?" I'm like, "Because I've been here all day. I'm here too. We both here. Sit down." This is what it is. Like, I gotta wait too, brother. Like, I don't control that, and sometimes it's frustrating because I would like to control it, and I get pissed because I feel like I can do a better service to my clients if I controlled everything. But that's in a perfect world. That world doesn't exist. So rather than using their skills to defend people at trial, much of attorneys' time is spent meeting with clients, negotiating with prosecutors, and settling cases. Like I said, 9 out of 10 cases are settled by plea bargain. So, everyone has his dream of being a trial attorney, but for the most part, all we do is do plea deals. I think I've had this year, 2020, because the year is new. I'm trying to think, did I have any? I haven't had a trial. Well, of course, but we have stuff going on with virus. But yeah, I haven't had any trials this year. 2019, I think I didn't have any jury trials at all, and I probably had I probably had maybe, and this is including civil stuff. I probably had maybe in a year 4 or 5 district court bench trials. But it doesn't mean I'm not getting good outcomes for my clients. It's just trials are few and far in between. So if you think you're gonna come in this business and you're gonna have a trial every day, you're gonna, for one, that's not gonna be in the best interest of your client. Now, if you're going to go to trial for you so you can get experience, but it's at the expense of your client and not in the best interest of your client, you, my friend, are terrible. You want to do what's best for your client. It's not about practicing to try to be a better trial attorney, because trial attorneys, that's kind of a misnomer. Attorney, there is a such thing as a trial attorney. That means it's an attorney who will go to trial, but really you're more of a best interest attorney. You're there to represent the best interest and for of your client. It's not about how many trials I get under my belt in a year. Some attorneys are lucky enough. As a matter of fact, honestly, an attorney that goes to trial all the time is actually super disrespected. If you're a good attorney and you're good and you've had enough trials where you did well enough and people respect you and respect you professionally, you'll get good deals. Plain and simple. When you go to trial, that means you couldn't control the outcome. You couldn't. That means you failed. So anytime I'm at trial, I consider that a failure, even when I win. It's a failure because even if I go through the trial and win, I still wasted the time of having to go through the trial to get the outcome that I wish I would have gotten through negotiation. I'd rather win for my clients outside of court or outside of the judicial authority by negotiating with the prosecutor than I would risking going to trial, because once you start that trial, you don't determine the outcome. I don't know if I'm going to win or not. I've had trials where literally my client was on tape not committing the crime, and I pointed it out, and it was a bench trial, and the judge totally dropped the ball. I had to appeal immediately for a new trial. I'm like, bruh, he's literally not committing the crime. So bad things happen in court, right? And I'm a cynical person about court. I believe, just especially in district court, bad things are gonna happen. When good things happen, it's like, woo, can't believe that happened. Awesome day. Get out of here with your clothes on, right? When good stuff happens, you don't stand there and celebrate. You back yourself out of that courthouse with your good disposition as quickly as possible, and you get to your car and you go home, and then you celebrate. So a lot of times, trial is not what you want because you're more likely to have a bad outcome, especially in district court. And we'll talk about judges in certain situations, but they are political officials. So you got to think you have someone that's politically compromised making decisions of guilt and innocence in the case. In a jury trial, they're not politically compromised, right? Because they're not elected; they're just regular people. But even with that, they can make mistakes at trials. Any trial, mistakes can be made, and the wrong thing can happen. And I'm not talking about because my client won and I'm a sourpuss about it. I'm talking about like, yo, he didn't do it. Like, there's an alibi. We got him on tape on the other side of town. Or we got pretty good exculpatory evidence, and he shouldn't be convicted. At best, they can't prove the case beyond a reasonable doubt. That means my client should go home, but sometimes that doesn't always happen, and we can't control the outcome. I've seen terribly unfair things happen in court. So to keep my client from happening to my client, I don't want to trial my cases. I want to get them settled without doing that and getting good stuff for my client so they can walk out of court without ever having to risk anything. So that's what it's about. Like I said, from experience with case outcomes and sentencing practices, the defense attorney is in a good position to determine if a case is winnable. The value provided in a plea bargain and what actions in the client are in the client's best interest. Now, clients don't always listen to you when you tell them what's in their best interest, but at least you told them. Success and another reality. Success is seldom clear, and victories are infrequent. Meaning so it's not about winning and losing. It's about getting your client out there, getting your client out of there in a better position than they would have been if you weren't there. That's kind of the definition of effective assistance of counsel. My client was better off than he would have been without me being here. Now that better off may not be great, but it's better than it could have been. And sometimes that's a win. Even in the law, sometimes there's a win. Like, the client was convicted, but he was convicted of a misdemeanor, not the felony he was charged with. I'll take that any day. That's a win, right? So it's not about guilty, not guilty, and guilty verdicts as much as it is about whether or not you've protected your client's interests and made it better for them than it would be if you weren't there. So most criminal defendants are factually guilty. Like most trials end in guilty verdicts. It is what it is. Technically, they shouldn't be because the burden is so high. Beyond a reasonable doubt, prosecutors should be losing most of their cases, but in actuality, they don't, because, of course, you have the force of the law enforcement officials in the state working against one person, and even though they have a high burden, essentially just by force and the show of force and all the show of authority. It is what it is. That's what you're going against. Um, So, like I said, most defendants are factually guilty, and most trials result in convictions. Success for criminal defense attorneys is relative. Like just what I said, it's not about not guilty or guilty. It's about, hey, better than it could have been. That's relative. Um, so what do I mean by factual guilt? There's a difference between you did it and you're guilty. You did it is factual. Something happened. Yes, I punched him. Guilty means guilty is a legal term. That means, are you legally responsible and going to be punished for this act? So you can do something and be justified and even though you did it, you're justified, so you're not guilty, or you had good reason. You're justified or you're excused for whatever reason, and you may not be guilty. In certain situations, you might have actually factually did something, but there's not enough evidence to prove it beyond a reasonable doubt. That doesn't mean that you factually did not do it. It just means the state can't prove it. That's another thing that where defense attorneys, we sleep well at night, because when we do win trials, it's not necessarily because we got a person off, or we proved that the person didn't do it. It's more about the prosecution losing the case. They have the burden of proof. All I did was expose what didn't make sense. Like, ladies and gentlemen of the jury, how can my client have been here and been there at the same time? Doesn't make sense. Find my client not guilty. So that was more about what the state or the prosecution didn't have, and when the deficiencies in their case, than it is about me having a strong case. My strong case is their weak case, right? I'm just exposing and telling the jury what's weak about it, and that's what we go. That's what I go off of. So it's not. So it's about whether or not they can prove it. So sometimes it's what it's about. A successful outcome for their perspective, from an attorney's perspective, is generally achieving as much of a reduction from an original charge and potential sentence as possible. So I'm making it better than it could have been or would have been without me. People and then another reality is the way people in the system view defense attorneys. Although defense attorneys play a critical role, we are vastly underappreciated. Like, what's that Chris Rock show? Everybody hates Chris. Everybody hates defense attorneys. They love us, and then they hate us. So it's a love-hate relationship. Oh my God, thank you. You got me out of here. Then next week you pissed at me, or you were pissed at me before, and now I got you a good outcome. Now you want to hug me. It's like, yo, get off me, man. You hated me last week. Don't hug me. Go home. You won. And sometimes I have that attitude. I'm allowed to be petty. There's no rule in this against petty. So some people treat you bad, right? Don't listen to you, disrespect you, and then you get the outcome you want. Now they smile and want to hug you. It's like, bro, I've been the same person and representing you the whole time. So you got to deal with people, right? Although defense attorneys play a critical role, like I said, they're underappreciated. Client distrust, prosecution, and police resentment for doing your job. So sometimes we have to do our job. We have to challenge the prosecution. We have to challenge the cops, but they're pissed at us for holding them to the fire. And judges resent us because when we do our jobs, that means now we have to run cases through the judicial process. You have to go to trial. Use state resources and time, and sometimes judges hate that. They wish when you plead guilty, you're making it easy for the judge, right? When you go to trial, the judge now has to be like, I gotta, all this evidence, all this stuff, I gotta do some work. Not saying judges are lazy, but sometimes judges are like, hey, you could have avoided this and saved me this, But a lot of times judges get mad, and that anger goes towards the prosecution because we're here because the prosecution didn't give a deal or didn't see it a certain way to keep it from coming here. So sometimes it's not as much about the attorney, the defense attorney, as it is about what the prosecution, the level of flexibility the prosecution had. Okay, the general public views defense attorneys as obstacles to the truth from time to time. Defense attorneys are another reality. Defense attorneys are paid significantly less than lawyers who practice in other areas, and PDs are paid less than prosecutors with similar experience in the same jurisdiction. So, it is what it is. We're not paid that much, but I love it. I would, like I said, now that I've said all that negative stuff, let me give you the positive. In spite of these realities, criminal defense attorneys still find their profession gratifying. I love it. It's a dirty job, but somebody's got to do it. Someone has to stand up for the little guy. Me, I've always been a defiant kid. I was a defiant kid. Got in trouble at school for for being defiant against authority. I didn't like when authority abused people and when someone was wrongfully accused. Sometimes I would speak out of turn and say stuff. That's who I am. So I think I'm where I belong in life as a defense attorney. So I love being here. It's a super exciting job. It's exciting work. I wouldn't want to be no paper pushing desk attorney that's doing all transactional work. That's not how I get down, right? So it's an awesome job, and it is fulfilling, and you do get the opportunity to change lives and be a counselor to a person. So it's awesome. But that is chapter 6. So that concludes the chapter 6 discussion. Once again, as I say at the end of every discussion, www.sagepub.com. That's www.sagepub.com. You can go there, go into search and do the title of the book, Criminal Courts: A Contemporary Perspective, 4th edition, by Hemmings, Brody, and Spahn. You can look those up. You look it up, find the book, click on the online resources, and go from there. They got online quizzes and everything, and you'll be fine. So if not, you can also go to edge.sagepub.com/Hemmings4E. So that's also on the back of your book. Let's see if I can get it close enough. It's right here. Let's see. So yeah. So you guys be good.